My name is Fayth Ruffin, and I'm with the School of Management, IT, and Governance, the College of Law and Management Studies at the University of KwaZulu-Natal. And today I'm going to be talking to you a little bit about Africanization of legal education. So now, when we think about it, the first thing to do is to get an understanding of the legal system. And in understanding the legal system, we know that that's a time-honored profession. We know that it's comprised of lawyers, judges, and others who make the system work, such as the police system, the courts, and so on. And in addition, we have the professional organizations that oversee who gets to be a lawyer or a judge. And feeding that trajectory are law students. So our focus today is going to be about education for law students and what that really means. Now, you often hear about the terms of decolonization of law school or any type of higher education or even primary education. You also hear about indigenization of education, Africanization of education. So in terms of the law school curriculum, we're going to look at what is taught, why, when, how, who decides, and who benefits. Now let's get back to those terms a little bit. So what is decolonization? Well, there are very many different definitions about how decolonization is perceived. But for purposes of this presentation, the way we're going to perceive it is that there was a structure set up through colonization. And this happened in various different parts of the world. And this generally involved European countries colonizing other countries in the global south. But colonization is not limited to countries. Colonization can also be, for example, the way that the legal profession or the law society is seen by some to colonize legal education, since they decide what it's going to be and what it's not going to be. But focusing on the term of decolonization is a bit challenging because it's really talking about something that we're trying to get away from. It's talking about cognitive imperialism, that people are taught to look at things a certain way, to perceive things according to certain ways of knowing, usually Westernized or Europeanized ways of knowing, thereby marginalizing different ways of knowing. So this cognitive imperialism is linked to colonization not being an event, but actually being a structure. So every day, wherever colonization happened, hundreds of years ago, it is reborn and continues to live so long as certain ways of knowing are marginalized or omitted. This actually is a form of what we could call epistemological violence. It's kind of like genocide. It's where only one way of thinking is privileged and where only one way of thinking is considered the right way to perceive knowledge. So in law school, we have to teach subjects that's going to enable the law student to set for their articles or be prepared to be admitted to the legal profession. And we have to do this because it is a professional degree, and we want to make sure that the lawyers are able to render the legal services that they need to render. So, but law school curriculum was really devised as a part of colonization. By that I mean that when different European countries colonized other countries in the global south, they brought with them their judicial systems. They brought with them their perceptions of the rule of law. And this continues to happen in terms of how this cognitive imperialism continues. By that I mean that Roman Dutch law, for example, in South Africa, is how the legal system, the Westernized legal system became underway. You might find English law that contributed to the development of the law in the United States or in Canada. You might find also English or British law in terms of how it influenced the colonization of the indigenous peoples in Australia or New Zealand. So these colonizers brought with them their worldviews of how the legal system should operate. And this is how law school curriculum continues, for the most part, to manifest itself. So what we're really talking about today is how to indigenize that law school curriculum based on the indigenous people who live in a particular country. We also want to think about the fact that the United Nations has accomplished inroads in terms of recognizing the rights of indigenous people. But national governments may not be quite as queued up or clued up as the UN has been. So what we want to think about is how is it that we can make sure that law school education, which is connected to national governments, be focused on the rights, the belief systems, the justice systems of indigenous people. Now, when I say indigenous people, I mean people who are indigenous to the land. Who decides what's going to be taught in law school? Who benefits from what's going to be taught in law school? Well, again, it's the legal profession of the law societies that decides what's going to be taught. So in order for that to change, there's many different layers of decolonization that would have to be unpacked for this indigenization to happen. And who benefits from the current way that the law curriculum is developed? Well, primarily neoliberalism as an economic practice, neocolonialism as a social-political practice, the privileged groups where race and class figure in. But by indigenizing law school curriculum, we're widening the net in terms of who would benefit, because there are indigenous justice systems in all parts of the world where people govern themselves long before the Europeans set foot. And these are the types of indigenous systems that we're going to be talking about. So now, what are the symptoms of legal education? Well, legal education is largely steeped in positivism, which means there are certain absolutes, there are certain rules of law that are considered to be the right way or the only way to perceive a certain situation. There is what we receive in law school education, the development of a centralized legal mind, where we focus on what are the particular facts in a case and whether or not those facts in a case amount to a prima facie case or to a legal right or a legal remedy, and that this is the only way to perceive what the situation is. Of course, that's overturned from time to time through case precedents, when the law is perceived as one way and then a persuasive attorney turns the tide and makes it perceived in another way. But another symptom of legal education is the fact that what matters is law in books. What matters is what the statutes say. What matters is what the case precedents say. In other words, there's no socio-cultural context taken into consideration in Westernized legal education. So what we want to start doing is unraveling the epistemologies underlying the way legal education is delivered, as well as all types of education in higher education as well as primary. But today we're going to try to focus on legal education. So African epistemologies is a term, a concept that we want to be able to understand if we want to indigenize and Africanize education. Now, remember I said decolonization is really just focused on trying to get rid of what colonization has done in terms of being a structure and still pressing forward with inequalities between people, whether it's based on class or race or gender or whatever the case may be. But when we start to shift the discussion to indigenization, we're talking about different epistemologies than exist under Westernized epistemologies, because indigenous peoples have their own worldview of how they perceive the world or their ways of knowing. A lot of this discussion is going to be focused on African epistemology, since this is where I'm greeting you from. So we have scholars like McDougall that tell us that one of the differences between Africanized epistemologies and Westernized epistemologies is that for Africanized epistemologies, we're thinking about what is the relationship that exists between the knower, the knowing, and the known. What can be known, how can the known be used, and what counts as knowledge? Now, if we think back when this structure of colonization started and began to be rolled out, it didn't just come with a social or economic political agenda. It came very much with an educational agenda. And that educational agenda is what resulted in an arsenal of sociologists, anthropologists, who had to justify why it is that people of color should be subservient to Europeans. That had to be justified. You know, at the beginning when slavery and all of that started, it wasn't race-based. It was only an economic imperial system. But then when it was discovered that if you link race to this slave trade situation, what will happen is you're going to have to justify it. So if you check the books, the history books, you'll find all types of derogatory things about African peoples, you know, that our brains are smaller than the brains of Europeans. So just check into the old texts, which a lot of which are still being used in terms of anthropology, and the knowledge that indigenous people had when the Europeans came was either driven away or marginalized, or most importantly, and this is where the epistemic violence comes, it was denigrated to the point of it not counting as knowledge. In other words, it's useless, it's worthless. So with African epistemologies, this changes the tide in terms of what counts as knowledge. In that, as we all know, the beloved scientific method in Westernized education, there's always a distinction between the knower and the known. In other words, if somebody's undertaking empirical research under the typical Westernized scientific method, there has to be objectivity. There has to be a distinction between the person who is conducting the research and who it is that is being researched. This is very different from African epistemologies or African ways of knowing. In African ways of knowing, the knower, the known, and what is being studied are all one. There's a holistic type of situation. There's not just one absolute truth in African epistemologies, but there are various ways of looking at the same issues. So now there are various ways or schools of thought for epistemology. Scholars like Tefelt distinguish between the rationalists, where the only source of power is the mental, the empiricists, which say that experiences are linked to senses, and these are senses even beyond the five senses. You've heard about the sixth sense or the seventh, or the world that is not always visible to the naked eye. And then the transcendentalists are those who, in applying knowledge, use both their experiences and their reasoning as a role. Another distinction between Westernized and Africanized epistemologies is that where Westernized epistemologies will focus on the intellect or the mental aspect, the African ways of knowing, or even the Indian ways of knowing, or indigenous ways of knowing in various countries include the spiritual element. The spiritual element is not separated from the intellectual element. And we're going to come back to that when we look at the various legal systems in South Africa. So thinking about African epistemologies as philosophies, let's focus on a few things. first of all, in terms of African epistemologies, when I say that, I'm not only talking about a way of knowing. I'm talking more broadly than that. I'm talking about ontology, axiology, cosmology. Now, let's just kind of unpack those for a little while. This is another distinction between Westernized epistemologies and Africanized epistemologies. And Westernized ways of knowing or ways of thinking, ontology, which is the nature of reality. That's all it means, is that how do you perceive reality? In other words, the adage is often stated that if a tree in the forest falls and there are no people around, does it make a sound? So if a person is thinking of ontology in the Westernized sense, they might not think that it really makes a sound if no human being can hear it. But in the Africanized way of thinking, or the indigenous way of thinking, the tree has rights, the tree has feelings, the tree has memories on its own. So yes, it does make a sound, and there are circumstances happening with these trees, even if there's no human being around. Axiologies really talk about values. What do you value? Often in research, especially in the law, we try to separate facts from values. That's a Westernized way of looking at it. Public administration, separated facts and values. Now, little by little, scholars are understanding more and more that you can't really separate facts and values because there are human beings involved in these facts. And human beings, inherent, they have values. And also, cosmology means more so of the spirit world, or also the universe as a whole, the galaxies, the stars, the astronomy, the astrology. So when we talk about African epistemologies, at least for me, when I'm talking to you today about this, when I say African epistemologies, I mean the oneness of ontoepistemologies, axiologies, and cosmology. Because in African ways of knowing, all of these are united. There's a oneness, there's holism. In addition to that, indigenous methodologies means that there are ways to collect data, to conduct research, so that indigenous people are not only involved, but that the methodologies are constructed in a way that will discern outcomes that are useful for problem solving. So there are various philosophical worldviews underlying African indigenous knowledge systems and African indigenous knowledge. But taken as a whole, there's that oneness or that holistic approach. So now let's dig a little deeper into understanding African epistemologies. So the African conception of knowledge and meaning deals with not just gaining knowledge and assessing and validating knowledge, but also the role of knowledge in human reality. So what this is really saying is that in the African or indigenous conception of knowledge and meaning, the human being is involved. The human being is not separated from knowledge acquisition or knowledge conveyance. And in this gaining of knowledge, it's experientially based. Experiences matter. There's not a desire to separate who a person is and their state of being from what they're learning or what they're understanding. So very briefly, there's a lot of different definitions for indigenous knowledge and indigenous knowledge systems. And the reason I'm bringing these out is because as we move toward the end of the discussion, what I'd like for you to understand from this presentation is that we can use African ways of knowing through indigenous knowledge systems that are really indigenous justice systems. And by understanding those indigenous justice systems, we can start to use the lens of African epistemologies. And remember, I mean that holistically with the ontologies, axiologies, and cosmologies. We can start to use that to conduct research about indigenous knowledge or indigenous justice systems wherever they may be, in South America, in Australia. It's a global situation in terms of indigenous justice systems or community-based justice systems. And we can begin to conduct research on those that will help us come up with findings that can then be fed into law school curriculum in order to indigenize, and in our case, Africanize legal education. So I'm giving you the big picture here as we go through this. So indigenous knowledge systems are intergenerational, systematic ways that are embedded in a cultural web in history and civilization. They form the backbone of a social, economic, scientific, and technological identity of a people. And for African indigenous knowledge systems or African indigenous knowledge, we are just geographically locating the indigenous knowledge systems. So for example, depending on what continent you're on or what group of people you're talking about, this term or this definition would apply to them in their own context. Because indigenous knowledge and indigenous justice systems are very much context-based. So in other words, this is another example of how in African ways of knowing, we do not separate the context from the facts, the values, and the circumstances, which is not true in the Westernized way of thinking. The context usually did not play that much of a role, although all this is changing. And maybe I should say here that when I talk about African epistemologies and Westernized epistemologies, I'm not trying to essentialize one or the other. I'm not saying that one is better than the other. I'm not saying down with Westernized ways of knowing and ways of thinking. What I am saying is that colonization is the structure. It was not an event. It still exists. It's ripe in the educational system. And in order to decolonize it, indigenize it, and in our case, Africanize it, you are going to have to look at various bodies of knowledge and allow them to rise to the surface on equal or fair footing. If something can be equal, it can definitely be fair. And leaving African history out of history in the academy, or leaving the contributions of India to mathematics out of statistics, it's all problematic. Leaving what happened at the Egyptian mystery system out of courses that deal with architecture is a problem. So I'm saying that to say that we're not saying that one is better than the other, but we need to historicize all that has been left out in order to bring it into the fold, not for it just to be localized and understood by the indigenous people who are practicing these ways, but for it to be able to contribute to the global pool of knowledge in an age of globalization. Because these might be local indigenous knowledge systems, but they're really in a global context and they're preeminent all over the world once we connect the dots. So now let's look at these three, there are at least three, well actually there's maybe at least four different parallel justice systems in South Africa. I'm going to just talk to you about three. But what's missing here and what could really add value is the fact that there are Islamic traditions that deal with community-based justice. And that too is another way of knowing justice. So what we're looking at, for example, are the non-state community-based justice systems. That's number one. Non-state means it's not funded by the country, it's not connected to any particular law firm or anything of that nature. Okay, then we have the traditional or the customary justice system. And thirdly, we have, of course, rule of law orthodoxy. So I'm going to just give you some ideas about how these are compared and contrasted, and then we're going to talk about how elements of the customary justice system and the community-based justice system can be used to indigenize and Africanize legal education. But before I do that, the community-based justice systems, again, these exist all over the world. We're going to even call them as part of indigenous justice systems. And this is generally where trained paralegals offer legal services to people often in remote areas. and they handle various cases from family disputes to domestic violence, child abuse, maintenance, social grants, entitlement, all those types of legal issues. In KwaZulu-Natal, for example, we have the Center for Community Justice and Development that's based in Pietersmaritzburg. We also have another community-based justice system in Phoenix, which caters to the community and deals with dispute resolution and mediation, which is promulgated in a lot of ways on indigenous or Indian and African ways of knowing. So what these paralegals do in terms of how cases are handled, they often involve mediation, where they bring the parties together and they discuss the issues. In the traditional justice system, we have Induna or Nkosi or traditional leaders or traditional council that are involved in the decision-making aspect of the customary justice system. But before I go forward talking about customary justice systems, I started at the beginning talking about how the legal profession, the law society colonizes law school and what's going to be offered in law school. The customary justice system that exists in the African countries and in other different countries is not the same as it was practiced prior to this structure of colonization. Because when colonization and apartheid came about, these indigenous justice systems had to be dismantled. They had to be restructured. They had to ensure that the colonizers were going to be able to control the traditional leaders or the Induna or anyone who was going to be overseeing these traditional justice systems. A good example of that is that pre-colonization, women were very much involved with being traditional leaders. But this was all changed during colonization and apartheid, and it became more of a male-dominated patriarchal situation. But that type of patriarchy did not exist prior to colonizations. Now, I think that's going to have to be another topic, because this is a story of gender and African women and how African women are very different in terms of their heritage and their historical role in families and communities. And that's why we have Westernized feminism and Africanized feminism. But again, that's maybe we should save that for another day. So in addition to that, in the rule of law orthodoxy, there are certain statutes and case precedents that determine things. So with the community-based justice systems and the customary justice systems, which, as I indicated before, that too needs to be decolonized, what happens is decisions are made on a case-by-case basis, which is contrary to what happens in rule of law orthodoxy, where case precedents are based on earlier case precedents. Another distinction between the indigenous-based justice systems and the rule of law orthodoxy. In both community-based justice systems and in customary justice systems, the ancestors play a very important role in terms of decision making. Divination plays a central role in determining how a case is going to be handled and who is going to owe who what and who is going to do what to and for who, for what reason. Unlike that, in the rule of law orthodoxy, the ancestors do not play a role in that venue. Also, in both types of indigenous justice systems that I'm talking to you about today, public participation is an essential part of the traditional justice system. For community-based justice systems, particularly the types of the community-based paralegals or the community advice offices that exist in KwaZulu-Natal, there are at least 15 of them now being supported by the Center for Community Justice and Development. The participants in the dispute make the decision. And this does not necessarily mean just two people. This also could be families participating in decision making. The public participation then exists in both of these venues, but there is no public participation or participant or respondent or plaintiff defendant participation in the ultimate decision making for rule of law orthodoxy. Rule of law orthodoxy is more individual rights based on the one hand. On the other hand, indigenous based justice systems are concerned with collective duties and collective responsibilities, so that whatever is decided is going to be on behalf of sustaining the community. Now, I know some of you are saying, yeah, well, you've heard about traditional leaders and they're not abiding by this, and they look for self-aggrandizement or self-enrichment. And as I said before, where this occurs, that's a key indication of the customary justice system likewise needs to undergo a decolonization and indigenization process, because there were a lot of checks and balances that existed in ancient Africa that were dismantled during the structure of colonization and apartheid, and these have never been reinstated. The checks and balances have not been resumed. So that's a good area of research, using African epistemologies to figure out how to help that to happen. So, as I said, families would be involved in the decision making for the community-based justice systems, and the public participation aspect in customary courts is another indication of participatory democracy. You often hear about how democracy is of Westernized origin and that now democracy is being pushed on African countries. But if you really go look at your history, you'll find out that democracy actually originated in Africa. You'll find out that prior to colonization, there was consensus democracy, where not until a council of elders that everybody on the council of elders agreed on a certain outcome would action be taken. So moving right along in comparing these justice systems, and I hope I'm lighting some ideas out there so you can go and conduct your own research about these matters. But remember to use the lens of African epistemologies and watch your sources as you take on the research. In traditional justice systems, the fines or penalties are paid to the wrong party. So whoever is perceived to have done something wrong to someone else, then whatever fines or penalties are collected, that goes to them. And that could include animal sacrifice. Because in African ways of knowing, when you wrong a human being, you don't just wrong the human being. And I know this is not only true of African ways of knowing, but in most indigenous ways of knowing, you do not just problematize the human being. More importantly is when you wreak havoc, so to speak, on an individual, you are also making problems with their ancestors. So you are doing things that are, how can I say, insulting or making things bad in the spiritual world. So it could be that the ancestors of the person who's committing the wrong and the ancestors of the person who's being wrong, they need to be in the story. They need to be involved in determining what the outcome is going to be, not just for that case, but going forward in terms of sustainability. Now, paying these fines and penalties or offering animal sacrifice to resolve disputes might be true in indigenous justice systems, but we know in rule of law orthodoxy, what happens is the fines or the penalties are determined by or paid to the state. So I hope you're staying with me through all of this and you're starting to see how epistemologies or ways of knowing or worldviews of how you perceive things make every bit of difference in the way certain subjects are studied and the way in which experiences are undertaken. So moving right along with the indigenous-based justice system, The sustainable solutions that come out in the community-based justice systems are for the parties to the dispute and their families to come up with a better way of how things should be handled in the community. Whereas in a situation with the rule of law orthodoxy, there's a definite decision on the outcome of the case, and that case may be appealable to another level of the court system, or it may be considered terminal and be the end of the game. Now, when in the traditional justice system, when cases are heard, and if the parties, at least in South Africa, are not happy with that, they can take that to the rule of law orthodoxy. I was about to say formal, but for people who are practicing community-based justice systems and traditional justice systems, those systems are just as formal to them as it is to the rule of law orthodoxy, or the Westernized way of viewing legal remedies. So a case from the traditional courts can then go to the Westernized courts, and that's where we really have a tremendous problem. You know why? Because in the community-based justice systems and in the traditional justice systems, the socio-cultural context of the situation matters. This is why we have public participation in the proceedings. This is why a collective view is taken, because this is also why case-by-case decisions are made, because you cannot, in African ways of knowing, in African indigenous justice systems, separate the context from what happened to lead to an injustice or to require a legal remedy. So where this occurred, who was there, the context of the community, how the parties knew each other from before, the socio-cultural context matters. But in the rule of law orthodoxy way of viewing legal remedies, the socio-cultural context is immaterial. It does not matter. What matters are the statutes. What matters are the case precedents. What matters are the centralized legal minds with which they endow us during law school in order to have this linear way of thinking and only look for whether or not these facts make a prima facie case and whether or not these facts arise to a legal issue. The social cultural context doesn't matter. And those facts, there's an effort to separate those facts from the values of a case. Not true in indigenous-based justice systems, where not only does the context matter, but this takes us back to cosmology and axiology, because the values cannot be separated from the context if you look at this through an African epistemological lens. So what happens when this case from the traditional court goes to the rule of law orthodoxy courts, is what we'll call that Westernized system? Well, different things happen depending on who the judge is. For example, it may be that the case is considered and there's an effort to see whether there is common law, mind you, Roman Dutch common law in South Africa, whether there is some basis there on which to decide this case coming from the customary court, or are there legal statutes that can help decide this case from the customary court. And there's a mismatch there, and hopefully, prayerfully, you can see that's a mismatch, because one system is dealing with the context, the social cultural context, and the other is disrobing it from the situation, making it less meaningful to the people who brought the case in the first place. By indigenizing and Africanizing in legal education, we can do something about this, because the African epistemologies can be taught in law school in a way that law students who will later become judges would be able to understand how these different epistemologies factor in with each other. In addition to that, the research that I'm about to talk to you about that needs to be done regarding traditional justice systems and community-based justice systems can lead to curriculum development, not just for legal education for lawyers, but also for professional development for judges and for others who work in dispute resolution or labor issues. Because if we're dealing with African people, we should be using African epistemologies. So now, how do we get to this Africanized or indigenized legal education? There are a lot of ways to get there. There are a lot of different theorists that exist now who can help us get there. Some are lawyers, some are not, but that's the thing about African epistemologies. It's a transdisciplinary approach. It's not the law alone. It's not the legal case alone. It's not the statute alone, but it's also the socio-economic context, the socio-cultural context, the socio-historical context that all of this is coming from. So we have to move away from our own colonized legal mind into the jurisdiction of self-intelligence, emancipatory education. Ancient African jurisprudence can help us get there. Kimberly Crenshaw's critical legal theory, along with other scholars, can help us get there. Nabu Derry's Africology, where he talks about the holistic viewpoint and describes how Plato, and by the way, of course, Plato, Aristotle, all these people who learned from the Egyptian mystery system and took this information back to Europe, for which they were criticized, but this information later formed the basis of Westernised civilization. Again, a topic for another day, but remember, Egypt is in Africa. The Middle East is a geopolitical misnomer. There's no continent for the Middle East. Again, for another day. So also helping us get there would be Hudson Weems' Africana womenism, which is one of the tenets or one of the ways of looking at African feminisms. The reason that that's important because in conducting research on community-based justice systems and traditional justice systems, we're going to really have to get a handle on gender and how it existed in pre-colonial times in various African societies. We also have Ferrer's and Biko's critical consciousness that can help us get to a socio-legal education that's emancipatory, as well as John Rawls's in social justice. So understand, we're not saying, at least I'm not saying, forget about all the Westernized scholars, forget about all the Westernized knowledge. No, there is some information there that remains useful. What I'm saying is we have not begun to scratch the surface on the African scholars and the African indigenous knowledge and the African origin of so many elements, including all the major Westernized religions. We haven't begun to scratch the surface, but that once we do, we would then be able to indigenize and Africanize legal education and others. There's a whole row or a whole array of emancipatory educationalists like Rancière, who talks a lot about self-intelligence and the fact that when students come to us in the first year of tertiary education, we tend to be ready to teach them what we think they need to know and what a university is supposed to do. Not enough attention is paid to the knowledge that these students, these first-year students, bring to tertiary institutions. We often wonder why they end up on probation or at risk when we have basically committed the same epistemicide that the colonial structure has emitted against us, when we do not value their own epistemologies and ways of knowing and their experiences when they come to us. So that's one type of way, one scholar, Rancière, who talks about emancipatory education. Also, there's W.B. Du Bois, who shares a lot of information on emancipatory education, even though he never really called it that. Now, that's true about so many African and African American, Indian, indigenous scholars all over the world. If you were to really look at what it is they were saying, even if they were a social activist, you can find so much there that can help reshape or indigenize, Africanize education generally. So from Du Bois, he always talked about this African-centered yet global, inclusive, communal, broad-based type of education that would be geared toward group leadership and collaboration instead of individualism and competition. Now, that's an African way of knowing. The collaboration instead of the individualism. Avoiding the competition and looking for cooperation. This is a team building we are trying now, many of us, to instill within our students. The communal aspect of education and it being broad-based. Not one person is doing better than the other person, but how is it that collectively we can move forward? These are all African ways of knowing that can be traced back to works like Chancellor Williams and the Destruction of Black Civilization, where he talks about that doing his research across the African continent and all the various African polities, there were constitutions in effect. And these constitutions were not just about politics. They also include the socio-economic realm, the spiritual realm, and all of these other realms in terms of a oneness. So although all these African polities may be speaking different languages and carrying out their particular constitutionalism ways in different ways, they all existed. So these are the types of things we need to uncover to understand a pre-colonial African context in order to see what we can use from that to indigenize and Africanize education now. There's a lot of these that I've already mentioned. We could also look at them as liberation deliberators. This is true about Nabudiri, as I indicated before, and his work on the holism in terms of African epistemologies. And I'm going to just keep moving now. Why Africanized or indigenized law school curriculum? That's a question you might ask. Well, there are a number of reasons for that. What is legal empowerment and access to justice? Is it that only people who have money and can afford a lawyer are entitled to justice? Is it that only people who are of a certain race are entitled to jurisprudence outcomes in a court of law? I think we need to consider that, because if we are going to look, for example, at South Africa as a participatory democracy, in a participatory democracy, that means all the citizens have responsibilities. All the citizens have obligations to make sure that they bring their talents, their skills, their energies to the forefront so that communities can develop and grow. Legal empowerment and access to justice applies to everyday people. People who may live in remote rurals in the hinterland of KwaZulu-Natal who are not interested in going to westernized courts of law and who are challenged with language barriers, transportation barriers, and other barriers that prevent them from accessing justice through rule of law orthodoxy. But yet they have entitlements. They should be able to be free from violence in their homes. If they have entitlements, they should have someone who's assisting them with going to home affairs or with going to the Department of Social Development to make sure that whatever it is that they're entitled to happens. They should be entitled to a legal empowerment that's going to give them more of an entrepreneurial mindset to determine what is it that they can do in the local economy from an entrepreneurship standpoint to improve their quality of life and improve their way of living. Should all that come from Africanizing and indigenizing law school curriculum? Why not? Because the law does not exist in a vacuum. The law does not exist in a silo. What good is the law if there's nowhere to apply it? What good is the law if there are no people who are going to benefit from it? And who's going to create it and implement it if there are no people? Of course, now, nature is just as important. I don't want the trees and the oceans to hear me saying all of this and feel like they're being left out, because they too have their own entitlement, but we're going to have to talk about that on another day. So these are some reasons in terms of legal empowerment and access to justice. Legal careers. All right, what is a lawyer? Being a lawyer means different things to different people. Maybe you want to be a lawyer because you decided that, you want to work at a big law firm and get the billable hours and change your social economic status or your prestige in the community. Or maybe you want to be a lawyer because you want to do that and other things, like make sure that people in the community have their rights protected and are able to participate in democracy. So legal careers are wide and vast. Every graduate from a law school is not practicing law, but a legal education gears you with a certain level of thinking and a certain way of viewing the world that makes you able to focus or adapt to any particular profession or employment situation in which you may find yourself. But what's lacking are the indigenous and African epistemologies in law school that can boost, widen, and expand the legal careers for law students. And as I've indicated, the advancement of democracy is a really big reason in terms of why we need to indigenize and Africanize law school curriculum. You know, there's an African Center for Excellence on Access to Justice. It was founded by 5 African countries, has recently expanded to 9, and they had this big conference in Rwanda recently where they all brought the chief justices and other members of the judiciary. And the conversation was about how can community-based justice systems and rule of law orthodoxy, or the judiciary in all these different African countries, how can they better work together? Our Chief Justice was there from South Africa. Other members of the judiciary were there in South Africa. And they are interested in how community-based justice systems can be better researched and the findings brought to the forefront about professional education of lawyers and judges, so these lawyers and judges can better handle the cases that are being determined in the customary law systems. So now you see how all of these legal plural systems are actually interconnected, but we're not getting the benefit of it because we haven't yet fully applied African epistemologies and indigenous methodologies to conduct research, develop curriculum, and even offer our lawyers and judges professional development seminars that are geared toward understanding African ways of knowing and legal remedies in their socio-cultural context. And these are the types of inroads that lead to socio-economic justice, which is another reason for Africanizing and indigenizing law school curriculum. So now who should do this? Who should Africanize or indigenize legal education? Should it be non-indigenous law academics? Should it be indigenous law academics? Should it be AIKS legal practitioners? Well, there have been studies on this, and I believe, for example, in Australia, there was indication of where they tried to embed indigenous ways of knowing or indigenous knowledge systems into existing law school curriculum. And there was a bit of a challenge because what came to the forefront is that the non-indigenous law academics, and by the way, at that time, there were no indigenous law academics in that particular law faculty, but they did try to bring in those versed in customary law. They found that the non-indigenous law academics were not interested because looking at legal systems through the lens of African epistemologies means giving up certain privileges. Certain privileges like the Westernized rule of law of orthodoxy being privileged. Certain privileges like race being privileged. Certain privileges like class being privileged. So even though they had workshops and retreats and seminars about how to embed this indigenous law aspect into their legal academy, it came to the forefront that it really should be the responsibility of indigenous law academics. Really? Because it could be that indigenous law academics are not interested in African epistemologies either. We have to remember that indigenous law academics, like all of us, have come up the rungs of Westernized education. Westernized way of looking things. Just because we have pigmentation doesn't mean we're clued up on African epistemologies. Just because we're black doesn't mean that we understand African ways of knowing, because our mental being has been trained according to Westernization. So, okay, the question of AIK as legal practitioners. Well, of course, they would have to be involved in Africanizing and indigenizing legal education, because as Du Bois would have said, collaboration, cooperation is important. It has to be broad-based. It has to pull from various venues. And as far as whether it needs to be a non-indigenous or indigenous law academic involved, I know you were feeling as if I left you just with an open question. It's still an open question, but my response to the open question is you need both. Because it's not about race, it's not about class, it's not about gender, it's about epistemologies. Anybody can come to understand epistemologies. If all these African people and indigenous people in the world have come to live out Westernized epistemologies, so can people from the global north or Europeans or Euro-Americans come to understand African epistemologies. It's very simple, but it does require a will, and it does require the use of not just your brain or your head, but also the use of your heart and the use of your spirit. Because again, there's the oneness of the epistemology, the ontology, the cosmology, the axiology. It's kind of like, take a look at the relationship between John Dubé in South Africa and Booker T. Washington in the United States, and see how they came together early in the 1900s when globalization was not in vogue, and what they did toward trying to create an educational system that dealt with not just the mind, but with the mind, the heart, the hand. It's an African way of knowing. The heart is not separate from African ways of knowing. So now another reason we want to Africanize or indigenize legal education is because settler colonialism was not an event. It's not about who landed where, in what year, in what century. What happened is that event grew into a structure, and that structure continues to be carried out every day. You and I, we're part of carrying it out every day. So we want to look at how it is that the onto-epistemological, axiological, and cosmological violence can stop. It's the epistemic violence that we want to stop. If we do not Africanize or indigenize legal education or any kind of education, what are we committing? Genocide. It's genocide. You're killing people. You're killing people just because of their way of knowing, just because of their outlook on the world. So this genocide has been part of the settler colonial structure from day one. This is why the higher education institutions have been used as a tool to teach in a way that you would think African people never did anything at any time in history. The legal profession, I'm going on to another reason now, the legal profession colonizes legal education. Now, we know that's not an overnight deal. We can't call the Law Society and say, hey, stop colonizing legal education. We can't call the American Bar Association and say, stop colonizing legal education. But what we can do is start to look at how, on the grassroots level, law school education can be more sensitive and more aware to its social, cultural context and what's happening in the community, which can be done through research. Now, there are some law schools that have been doing similar things for many, many years, and those who are very connected to their communities. So those law schools might be a good place to start to get ideas on how to popularize this. Because, there was a time when clinical law schools were not in vogue, so to speak. But now when you look at it, just about all law schools have a legal clinic. But there was a time when this did not exist, and the law school was in its ivory tower only for the elite. So just as if now that legal clinics have become a global phenomenon with law schools everywhere, so must Africanization and indigenization of legal education. Another reason that we need to Africanize and indigenize legal education is because this will help us conduct research that leads to the institution of traditional leadership being decolonized and being indigenized. So all in all, this is a battle against privilege. So I've been talking to you a little bit about the research project, so let's look a little deeper into that right now. How can we construct African indigenous knowledge or African indigenous knowledge systems, or we could say African indigenous justice and African indigenous justice systems? How can we construct those socio-legal projects in order to conceptualize legal research problems through African ways of knowing? Legal analysis and legal writing has a tendency to draw from books and case precedents and statutes. We want to look at how to combine legal research and analysis with social science research and analysis. So when I say social legal research, I'm not talking about the sociology of law, right? I'm not just talking about still staying in the books. I'm talking about going into the field. I'm talking about having everyday people participate in providing information that leads to research findings that's going to help them solve their legal problems as well as their socioeconomic problems. Because community-based justice systems particularly are transdisciplinary, just like African indigenous ways of knowing. So what we could do is determine conceptual or theoretical frameworks that encompass a socio-cultural and legal perspective. What's another reason that that will really help us? Because in African countries such as South Africa, there exists the African living law. Now remember I talked to you about how the institution of traditional leadership was colonized and how customary law itself was colonized. In fact, there are different types of customary law. There's the official version, which has been approved by Westernised rule of law orthodoxy officials, and there's the unofficial version, which is more concerned with African living law, which still exists and is being practiced in communities every day. This research can help us uncover the realities of this African living law, and the information or the findings from this research can then be taken to not only indigenized and Africanized legal education, but can be made available to judges and lawyers so that these judges and lawyers can begin to decide cases in line with African living law that's still in the contours of the Constitution of South Africa, but allows the African living law to develop itself. African living law is dynamic. It's not like the official version of customary law. It's not like the legal precedents. It's not like the statutes. It's living, it's happening, it's occurring, it's dynamic, it's on its feet. The reality is always changing. Just like any other African indigenous knowledge, African indigenous justice systems are not stuck in some stagnant way of looking at things. People are often confused about that. You talk about African indigenous knowledge, they think they're trying to take you're trying to take them back to old times and do things like there used to be. It's not that. It's not that at all. What it means is understanding these different ways of knowing and these different ways of looking at things so we make them real in this day and age. So this type of research can help us understand African living law so that it can develop on its own and not be subject to continuous epistemicide and not be subject to legal genocide of being marginalized, denigrated, or omitted. We can design indigenous methodologies that will enable us to do that. And this will help us sustain the oneness that I've talked to you about so much more earlier about the ontology, epistemology, axiology, and cosmology being one. So we can assess these findings for curriculum development, but we have to understand we must study African living law, indigenous justice systems through African ways of knowing on its own merit. So by that I mean that you can't use a westernized lens or worldviews like positivism in order to understand African ways of knowing on its own merit. Because of the dynamism that exists, you need the types of philosophical worldviews that are more integrated and susceptible to dynamism and multiple truths. So by understanding how African ways of knowing relate to law and justice, and how African ways of knowing informs legal education, we can determine which elements of African indigenous justice systems can be useful for contemporary realities and legal practices in ways that solve problems. You know, at the University of KwaZulu-Natal, we've recently rolled out a strategic plan that is concerned with conducting research for problem solving, that is concerned with the impact that research has on the community. So understanding African indigenous justice systems can yield findings in a number of ways that will solve problems and help inform policymaking. Because in a participatory democracy, individuals, the everyday person on the street, in a rural community, needs to be involved in how policies are going to be made and carried out. So the questions that I'm going to leave you with are, how do we translate African indigenous justice system socio-legal research into outcomes for emancipatory law school curriculum development? We can do this. How can Africanized law school curriculum development improve socio-legal research? The more we go to the field, get the findings, use the findings, create curriculum, take that curriculum, let it lead us into how we can improve the research and how we can go back to the field to dig deeper and understand realities in a way that solves legal and socioeconomic problems. How can this promote access to justice and legal empowerment? In a myriad of ways. Because access to justice and legal empowerment are not limited to law. Also, we can build new legal careers and advance the legal profession in a way that ensures inclusivity. This means a synergy of Africanization, where all of these really come together to generate emancipatory socio-legal research in the field that begins to indigenize and Africanize legal education. So thank you for joining us, and we hope to see you again in the near future.